Assalamu alaikum wa rahmatullahi wa barakatuh. As we welcome our listeners and viewers this evening. This is Wednesday nights with Inayat Wadi. The time is just gone 5 minutes past 7 p.m. Central African time. It's our weekly panel discussion, and our discussion tonight is going to be focused on PEPUDA, which is the Promotion of Equality and Prevention of Unfair Discrimination Act. Now, the amendment to this act has created a lot of discussion, and it raised a lot of concerns as well. At the same time, we have seen calls for submissions of objections, and this deadline is obviously the 30th of June 2021. And we need to obviously understand why we as South Africans need to be concerned with regards to the amendment bill. Now, this is absolutely important, where previously we've had brief discussions on the subject, but tonight we have assembled a panel, and we're going to take this entire discussion in depth, and also to understand in detail as to why there are calls for all these objections. Now, part of the panel this evening consists of Michael Swain, who is the Executive Director of FORSA, which is Freedom of Religion in South Africa. We've got Ahmed, Mansour, Imam, Sheikh, Member of Parliament with the National Freedom Party. Also, Advocate Glynnis Breytenbach, the DA's Shadow Minister of Justice and Correctional Services. And we have Dr. Faisal Suiliman, the Chairperson of the South African Muslim Network. To all the panelists, good evening, assalamu alaikum, and we welcome you to the discussion this evening on Salam Media.
Thank you. Good evening.
Yes, I'm just going to go around briefly. And Michael, I see you right at the top of my screen. So that is the order that I'm going to go through. Just very quickly, Michael, a quick introduction of yourself, and just a brief overview in terms of this the act that we're looking at PEPUDA, and also in terms of what are some of the concerns.
Thank you so much, and great to be on the show. Yeah, my name is Michael Swain. I am the Executive Director of FORSA. We are a legal advocacy group, and we essentially are exclusively dedicated to watching over the religious freedom rights that we're granted under our Constitution, specifically Sections 15 and also, of course, Section 9, which is the Equality Clause. The reason that we're concerned is not obviously about equality and the prevention of unfair discrimination. That's a very good thing. And PEPUDA, which was the act, which is an acronym which has already been explained, otherwise known as the Equality Act, was passed in order to give effect and, to an extent, teeth to the Section 9 of the Constitution. However, what we are very concerned about is that we believe that PEPUDA has actually been very effective. It has done its job in that sense. It has helped to promote equality and to prevent unfair discrimination. And there are also other remedies in South African law, even common law remedies like crime and injuria, for example, which also protect people's human dignity. So what concerns us is that this amendment bill has suddenly appeared in front of us for public comment. It was released just before the Easter weekend and the Ramadan festivities, etc., on the 26th of March, and only 30 days were given for comment. When we questioned this, we were told this was a matter that the Department of Justice needs to deal with urgently. And we can't understand, number one, the urgency, and secondly, we're very concerned about what this does. It dramatically expands the scope of discrimination, the scope of equality. It dramatically expands liability, and it allows for significant levels of direct government intervention into, even at a micro level, to organizations, faith communities, in fact, just about any community, because there will be a positive duty on you to effectively comply with the provisions, and it will overhaul all other legislation in South Africa, because it is the preeminent piece of legislation in South Africa. All other pieces of legislation are basically subject to PEPUDA, and therefore there will be a review, if you like, in terms of the provisions of the PEPUDA Amendment Bill if it comes into law in its current form.
Well, thank you for that, Michael. Ahmed, Mansour, Sheikh, Imam.
Can you hear me? Can I come in?
Yes, you can come through.
All right. Assalamu alaikum and very good evening to our colleagues out there and our listeners. My name is Ahmed Mansour Sheikh Imam. I'm a member of parliament and the leader of the National Freedom Party Parliamentary Caucus in the National Assembly. Our view is very, very simple. We believe that there is adequate protection for any forms of discrimination already in the Constitution and in terms of the Act. And we don't believe that there is any urgency in this particular matter to need to amend the Act. But what is very, very important to notice is that there appears to be a sudden rush to have this bill, this amendment approved. And, there's a great percentage of people that are actually opposing this. So the question that arises is, who exactly is pushing for this bill to actually be passed? And that's what we don't seem to understand. However, our view is that this is going to lead actually address any shortcomings that already exist. Now, the other issue I think that we are very concerned about is the far-reaching consequences and the detrimental effect this will have if this is actually passed. Remember, there's going to be more and more litigation, which is going to be on the increase. There is no doubt about it. Already the justice system is already overwhelmed. They talk about also providing legal resources to the claimants, particularly in this particular matter, which means there's going to be an unfair edge over those that the claims are being lodged against. Now, we feel that, what we found is that over a period of time, all these bills that come to Parliament and don't go out for public participation, and this is the concern we have. Despite all the objections that you have from South Africans, the bill still comes there, and based on majority, political parties tend to pass this bill. Whether you support it or you oppose it does not make much of a difference. Now, what we can't understand in this case is that who particularly is pushing for this bill to be amended. Because if you go through the Act, I think Ms. there has already alluded to that, there is, at the moment, we believe, enough protection for those people that may have been discriminated in one way or the other. But if you talk about religious protection now, let's look at it from a Muslim, an Islamic point of view. In other words, if your Islamic faith or religious conviction is such that you will not promote in any forms of lesbian, gays, bisexual activities, then already you're going to fall foul of this amendment that they are bringing. And we believe that in terms of the freedom of speech and the freedom of you to choose your particular religion and your right to express yourself in the manner you want to, without, of course, affecting the other party, should continue. So really, we don't understand what is the rush in this matter, and we believe that this must be opposed by all people in the country to try and prevent government, particularly, having an edge over deciding what they believe is discrimination and not.
Well, thank you for that. And we're going to go now to, I see Advocate Glynnis Breytenbach. If you could unmute, please.
Thank you, and good evening to everybody. I find myself in agreement with the previous two speakers to a very large degree. The DI is very concerned about the sudden rush to push PEPUDA, this amendment bill, through. I agree with Sheikh Imam. We don't know who's pushing for it, and we're not sure why. But we believe that South Africans should be quite worried about this bill and it being pushed in this fashion. And a careful analysis of the bill has exposed a variety of significant concerns, some of which have already been raised. So there's expanded definitions of discrimination, and it removes the requirement of intention for culpability. This is going to result in individuals being guilty of breaking the law without even being aware of it or without having intended to do so. It will extend the ambit of culpable discriminatory acts to an unacceptably wide degree. It's going to have a massive impact on freedom of religion, as Sheikh Imam has already pointed out, which is really something that we should try and avoid. I think there are many unforeseen consequences in the bill as it now presents itself. And the inclusion of vicarious liability is a matter of great concern. Employers and other institutions are going to find themselves being held liable for acts that they have absolutely no control over. So just very briefly, we're very concerned about this amendment bill, and we think that South Africans should correctly be very concerned and should keep a very stern eye on this public participation process. Thank you.
Thank you for the Glynnis. Faisal?
Thank you, Inayat. Assalamu alaikum, and good evening to Michael and Glynnis. Yes, not to repeat what has already been articulated. Firstly, I think I'd like to, or we'd like to, acknowledge and thank Michael and Freedom of Religion SA for bringing this, highlighting it in the public sphere, doing the work. I'm looking at their website as we speak. The videos that were made by their colleagues, etc. And thank you, Michael, for that. I'm sure Glynnis and Michael can speak more to the legalities later on, but we have two examples that may just point this, that are pertinent in this case. First of all, the penny sparrow case clearly showed that, as Michael and others have said, there is adequate legislation to tackle. Yes, perhaps there are clauses in terms of unfair discrimination that can be expanded upon, but clearly not to the extent. I mean, some of this is just frightening. The leeway that is potentially being given here to politicians, especially, and with respect to Sheikh Imam, I don't ever want politicians having this sort of power, not just on my religion, but clearly even in aspects of other aspects of my life. And this is what these amendments propose. Secondly, we had a case, perhaps Glynnis and Michael are not aware, but it's pertinent. Last year, in a predominantly Indian suburb in sort of south of Durban, and within that Indian suburb, probably predominantly Muslim, you had a gentleman who was living next to a madrasa. He's of the Hindu faith. And the call to prayer given in Arabic was being recited, not on a PA system, just being recited for the worshippers to come to prayer. Now, anyone who's lived in South Africa, especially post-apartheid, probably is familiar with these call to prayers. People who now moved into suburbs or previously white suburbs will know the consternation it causes some of the old people. Many of them, Glynnis is the party supporters, but anyway. So this gentleman decided that he doesn't like the sound, and among the clauses that he mentioned in an interview was, as part of this call to prayer, Glynnis and Michael, is the words, "There is only one God." And I'm sure, as you know, Islam is a very strictly monotheistic faith. And he said that prayer, that call to prayer, notwithstanding, it's not meant for him as a Hindu. It's read in Arabic, impugned on his dignity, and therefore he objected to this prayer, call to prayer. And strangely enough, the court held in his favor, and even more strangely, the court denied the leave to appeal. But of course, that is being taken up. But the point being made that under laws at the moment, you've had two cases that already start to show there is a legislation, there is precedent for dealing with discrimination or unfair discrimination, and clearly the type of leeway that is being proposed here it's completely unacceptable. As I think others have said, it is an encroachment. It is almost going to end up being an attack on religious freedom. And of course, notwithstanding the fact that we have differences, especially some of the Abrahamic faiths, as far as the LGBT community is concerned, we do see that as potentially a serious problem. I think it's important for us to differentiate between, for example, homophobia and discrimination, and being true to our religious principles. If I can give an example, in Islam, any sort of sexual contact out of a married male and female couple is forbidden. So is alcohol, and so, but we do not, hang Muslims who drink or who may have had an adulterous relationship. We don't deny them, entry into the mosque or to be buried in a Muslim cemetery, notwithstanding that those are serious sins in Islam. And similarly, we clearly have the vast majority or overwhelming majority of Muslim scholars will say that those same-sex marriages are unacceptable. But it's different to saying we are homophobic, or we're going to go out there and discriminate and attack people from the LGBT community. So there is clearly a difference, but certainly our religious faith, our religious beliefs cannot be impugned on. And these amendments clearly, as Imam has mentioned, open the door for such.
Yes, Michael, to bring you into the discussion, and if you could unmute, please, Michael. Obviously, when we're talking about PEPUDA, it outlaws unfair discrimination on the basis of race, gender, sexual orientation, age, whatever it is at the end of the day, language, religion. But we are now in a democracy, and 26, 27 years down the line. And over the years, we've seen so much legislation come through in terms of outlawing discrimination, in terms of ensuring equality as well. And being a democracy for so long, and I accept the fact that we are a young democracy, and 20 some odd years later, we are still now talking about this amendment to this bill. And the key question here is defining what is discrimination, defining what is equality. Now, these are huge question marks that are being raised right now, Michael.
Yes, and I think what you say is very important. It's the definition, the meanings that are given to discrimination that is so difficult, and also perhaps how this PEPUDA, how the Equality Act actually operates. Discrimination is defined, and I'm going to read the definition, as an act or omission which imposes a burden, obligation, or disadvantage that it does not place on another, or withholds benefits, opportunities, and advantages that it grants to others, obviously on the basis of the categories that you've given. So here's how it actually works. There's a twofold test in this particular Act of Parliament as it currently stands. If you can show that you have indeed been discriminated against on one of those protected grounds, the burden, if you like, of proving that what you did was fair then shifts. So if I'm the one who is alleged to have discriminated, once they've shown that there is discrimination, then I now have to show that that discrimination was indeed fair. It is assumed or presumed to be unfair. And I now have to basically justify myself. I'm in that sense guilty until proven innocent. But the difficulty comes once you're caught in the net, so to speak, once they have proven discrimination, which is now unfair, is you then have to pass the test in the Act of fairness. And even though in our Constitution, in the equality section itself, and as the Constitutional Court has already ruled, there is no hierarchy of rights in our Constitution. All rights are basically equal, and if they do come into conflict, you have to find the best way of balancing them so that the maximum benefit and if you like, blessing of those rights still remain. The test is weighted very heavily in favor of the person who alleges the discrimination. So if I'm now trying to prove fairness, I have to, for example, they're going to take into account the context in which the discrimination is taking place. They're going to take into account whether the discrimination impairs human dignity, particularly, and this is one which is often catches people who are trying to prove fairness, whether the complainant's position in society and whether he or she suffers from patterns of disadvantage or belongs to a group that suffers from patterns of such disadvantage. So you can see that that is exactly why, for example, when people who are trying to say, well, the reason I discriminated against was actually not based because I'm trying to be bigoted or whatever it is, but it's just because of my sincerely held religious convictions. It's my faith that causes me to act and to think and to do certain things or to not do certain things. And that is what religious freedom is supposed to protect. It's supposed to protect your right to not only believe, but also to live out your faith. Well, of course, you can see from the test that it then becomes extremely difficult to prove fairness. And that's often why people who have discrimination against them, and they've done so, if you like, for whatever reason, for a religious reason, that doesn't really count. I'd like to maybe just give another case that we're also dealing with at the moment, also in KZN, Dr. Faisal. which might also interest you. This is a case which was reported to us of a young evangelist, a Christian evangelist in this instance. Also took place in Chatsworth in KwaZulu-Natal. And he made statements to the effect, which again, quoting from the Bible, quoting from scriptures, that Jesus is the way, the truth, and the life, that he is the one and only God. I mean, very similar, as you say, the Abrahamic faiths have a very, defined view and belief of the exclusivity, if you like. And by the way, just to mention, FORSA, we are neutral when it comes to faith. We believe that everybody has the right to believe whatever it is that they choose to believe, obviously within the bounds of law. So we are not pro or con any faith or ideology or any doctrine for that matter. We just believe people should be allowed to believe what they do. Anyway, this man, a young man, again, found himself in court. Three particular groups, again from, in this instance, the Hindu faith, opened litigation against him under PEPUDA. And basically, they called what he said hate speech. And they even tried to open cases with the police of crime and injuria, which is a criminal action against him. And they want him, among other things, between them to pay 400,000 rands worth of damages, to do 200 hours of community service, and to also make a commitment never to speak or teach or mention those particular scriptures in public again. I mean, that is egregious when it comes to religious freedom rights. And yet, as you do find, once you're caught in this net, to prove that what you said is fair, even if it's based on your sincere convictions and beliefs, that even under the existing act is very hard to get out of. And of course, when you broaden the categories, as we'll probably discuss in a moment, and you make discrimination and the basically the net that much wider and liability that much wider, as Advocate Glynnis has mentioned, it becomes extremely dangerous, and it is totally contrary, we believe, to the constitutional freedoms that we are supposed to have guaranteed and that we should be allowed to enjoy.
Yes, Ahmed, Mansour, Sheikh Imam, just to bring you into the discussion now. My big concern, and you've alluded to it, and Michael has also alluded to it, in terms of rushing this piece of legislation, and also trying to understand the wisdom, the thinking, the who is behind this legislation. Now, if those are unknown, and this is a very, very important amendment bill that is going to be passed, that is going to have far-reaching consequences for each and every South African, and organizations, institutions, companies, and the like as well. And Faisal also made mention in terms of, putting our lives, for want of a better term, in the hands of politicians who are actually pushing this bill without thinking this through.
Well, let me start off by, Honorable Breytenbach is here with me, and she will tell you that, we actually are surprised that this, bringing this bill for public comment and giving a deadline 30th of June, it's a surprise and shock to us as well. And there is a high level of urgency in this matter, and we cannot seem to understand. If you just go into the current bill, if you talk about race, or you talk about gender, you talk about marital status or religion, there is adequate protection there right now. So we can't seem to understand why. I can understand on the other aspect that they talk about the bill seeks to expand the definition of equality on equal rights and access to resources. That you're not going to solve by amending this bill. That government should get its acts together and address the socio-economic conditions under which our people live. That's what they should actually be addressing. So I'm not sure what is actually the purpose of wanting to rush this bill. But what is worrying me is this, and I think Honorable Breytenbach will concur with me, that time and time again, bills are brought to Parliament, and there has been public participation in the process, and we get a large percentage of people that are objecting, but the bill still comes to Parliament and get passed. And that's the problem we are sitting. So the question is, what is the purpose of this public participation process if the bill is still going to come to Parliament and get rushed through and get passed? Now, that's the problem we are sitting with. And I've said this before, that it would appear that they ignore the public comments that come through, and they've taken a decision before they send it out for public comment that this bill is what we want, and we're going, and this is what is happening here. So whatever objection you're going to get by the 30th of June still means that their plan is to come to Parliament and based on majority vote are going to come and push for this bill to be approved. And that's the problem we are sitting.
Yes, and
Perhaps,
also just want to remind our viewers and listeners that we invited the South African Human Rights Commission, obviously, to participate, but sadly they could not. And also, I just want to just confirm, Glynnis, both you and Ahmed Mansour are part of the Justice Parliamentary Portfolio Committee.
I certainly am. I'm not sure that Sheikh Imam is.
No, I'm not on the Justice. I'm on many other committees, but not on the
Okay,
And
no,
I'm
brilliant.
on the Justice Committee. I know you tried to get hold of the chairperson of the Justice Committee and you were unable to as well. Yes.
Yes. Now, Glynnis, obviously,
Perhaps.
I think from what Ahmed Mansour is obviously saying, Faisal, I'll bring you into the discussion now. The key issue here is, inviting all this public participation. Is this just a case of going through the motions? Is it just about, saying that, listen, we can appease the people of the country. We invited you for your participation and whatever sentiments you want to express. But the key issue here is, does the sentiment of the public matter? Where is now the people shall govern? Because that is a slogan that obviously we've heard time and time again in this country. Is there such a principle, or can we read into the slogan of the people shall govern under the circumstances that Ahmed Mansour has just mentioned?
Well, it's a thorny issue, and it remains a thorny issue. To a very large degree, I agree with the Honourable Sheikh Imam. It's disappointing when legislation comes to Parliament that is not popular, that hasn't been supported by the public. But of course, there's a majority in the National Assembly and in the National Council of Provinces that allows legislation to be passed that is not always popular and not always supported. That being said, the Constitutional Court has set quite a high bar for public participation, and certainly the legislation that comes to the Justice Portfolio Committee will make a point of ensuring that the requirements for public participation have been scrupulously met. But again, that may well be the case, and there may be many objections to the legislation. But the governing party has a huge majority in Parliament, and if they want to pass legislation in the ordinary course where a simple majority is required, they have no difficulty in doing so. And so there may be many South Africans who don't support a piece of legislation and it will get passed anyway because the people shall govern is seen as being the people have voted the ANC into Parliament with a huge majority, and so in that fashion they shall govern. So that's the argument. But it is again deeply concerning that this piece of legislation that has such very, very far-reaching consequences is being sprung on us in a surprise move, really, and is being rushed to this extent. Another matter of great concern is that the public portal for public comment and objections at the Department of Justice, that email address has been dysfunctional for some days now.
Wow.
So public comment is being bounced back. People have complained about it, and they tell us it's been fixed and that the mailbox was full, but now they've increased the capacity of the mailbox, etc., etc. But the fact, and they've made another email address available, but that's not easily accessible to the public. So one doesn't know how many comments from the public have been lost in this fashion, and how they will be retrieved, if they will be retrieved. That needs to be looked at, and if necessary, the closing date for comment will have to be extended, and this may well interfere. It may render the bill unconstitutional as far as public participation is concerned. You can't expect the public to go rummaging around looking for addresses to send comments to. The address that's given must be the address that works. Many South Africans have a lot of difficulty accessing sophisticated means to send their comment in on an email address as it is. You know, they can't be going 3 or 4 or 5 times to try and submit it. So that's a matter that we've been trying to deal with this week, and I'm told that it has been attended to, but the fallout of it, you know, we'll have to check. We have no idea how many public comments have been bounced back and may have been lost, and how they will be retrieved. And that's a matter of grave concern, because each and every member of the public who's taken the trouble to comment should have their comments at least paid attention to, read and considered. Otherwise, there is simply no point in doing it. And then it is paying lip service to the requirements of the Constitutional Court, amongst other things, and it will render the whole process unconstitutional in the end. So that's something we really do need to keep an eye on. Thanks.
Glynnis, I'm just trying to understand the process. Would those objections come through to the Parliamentary Justice Portfolio Committee?
Not necessarily at the moment. The address is a Department of Justice address. They go there, then they get sifted by the parliamentary administrative staff. They go through them. They say these are for, these are against, these are the numbers, etc. So, and then we get a summary of it. It's always been my view, not necessarily a popular one, but it's always been the view of the DA that we should. That MPs are required to actually interact with these objections and submission. It's no good getting a summary from the parliamentary staff. It's actually our job to go and sit and look at them and read them and digest them and form a view, which is what we've done, for instance, with the previous ad hoc committee on land reform. We went and sat and worked through those many thousands of submissions. I believe that's our job. We can't leave it to the parliamentary staff to summarize these things and then we read a quick 2-page précis. That can't be our job. So at some point, yes, these objections and submissions will have to be dealt with by the committee, and in my view, all the MPs will have to sit and read them. You can hardly form a view and gauge a feeling of what people are feeling and thinking if you don't read these submissions yourself. So at some point, yes, we'll have to do it, but that won't be before June. You know, the closing date for submissions is June. Then there's a very long process of collating and sorting into some sort of order all of these submissions.
Thank you for that, Glynnis. Faisal, you were going to make a comment, and you can make that comment. And before I obviously raise the next issue with you.
I was going to say tongue in cheek that perhaps the rush is because I know of course, elections for National Assembly are a long time away, but perhaps the ruling party is concerned in the next one that I'm sure Glynnis is going to like this. Is not assured of that majority, and therefore they need to rush this. Yeah, well, the municipal elections may give us some indication, but no, look, what is clearly worrying, Nayat, is firstly, if Glynnis, as being part of this portfolio committee or the Justice Committee in Parliament, is not aware of perhaps who's pushing for this behind the scene, which interest or lobby group, that is concerning. Secondly, it appears there's almost deliberate obfuscation going on, and that is even more concerning. Then, as Glynnis has highlighted, there's obviously a gatekeeping role, because if the Justice Department, from what it appears to be, rushing this, giving such little time for public comment, are the same people doing the gatekeeping role, worse things have come out, in the past. So it concerns me that if it's someone making a 2-page précis and passing that on such an important thing with the far-reaching, and that's the point I think everyone has made, the extremely far-reaching consequences, that's not good enough. And I think, for me, it's not good enough now to send this email to Ms. Bayat or whoever this email address is. For me, everything I do now is going to go to the presidency. I'm going to be sending it to the stand-in Secretary General of the ANC. I'm going to be sending it to the presidency office, and I would think that all of us that are now opposed to this need to look at other strategies to bypass this obfuscation, this obvious obfuscation. I mean, I can't believe, emails getting blocked, no one attending to them. Yes, people are working from home, COVID, we're all dealing with it. So this is worrying for me, and I think we need to a greater collaboration here beyond the 30th of June deadline to approach, the ruling party itself, and I think political parties, interest groups need to perhaps work together after this to bypass any gatekeeping role or any shortcut that perhaps appears, from what we see, there appears to be an undue rush to pass this, and it would really be interesting to be able to find out which interest group is which lobby group is behind this.
Yes, Faisal. Michael, now, obviously you spoke briefly about the test for discrimination, but just getting into the meaty stuff and looking at drilling down, looking into some of the detail that is associated with whether we're looking at the test for discrimination, whether we're looking at equality, whether we're looking at fairness, and all of it at the end of the day obviously is likely to have consequences. And just to look at some of those likely consequences and also looking at some of the detail if we drill down, because this definition obviously is very broad, it's extremely broad as far as the discrimination is concerned, but just looking at some of the detail, or as I said, the meaty stuff that are some of the underlying issues playing out.
Yes, well, absolutely. I think the first thing to perhaps look at is the way that it expands the definition of discrimination. And discrimination is basically defined, or they've added in two very concerning additional categories. If you believe that you have been caused prejudice, or something or someone has said something or done something that undermines your dignity, that can constitute discrimination. And as I said before, the most important thing to understand is that once you've shown discrimination, it is deemed to be unfair. And so how do you know whether you have caused somebody prejudice or whether you have undermined their dignity in some way? Bearing in mind that, as Advocate Glynnis, Honourable Breytenbach said, intention is irrelevant. So whether you meant to or not, whether you intended to or not, there's no requirement for me to have meant to have discriminated against you or meant to have said something which has undermined your dignity or prejudiced you. So with intentionality gone and these categories now becoming so completely subjective, to be caught in the net of discrimination, which is then deemed to be unfair, and you now have to prove that what you said or did was fair, it's almost strict liability. It's almost impossible once you're caught in this net to get out of it. And I think that the other thing which is important to understand is that, as we have said, liability is also drastically extended. So, for example, if you cause or encourage somebody to discriminate, and that can be very oblique. If you cause, encourage, or request another person to discriminate against another person, you are deemed to have discriminated against such a person. So, for example, let's supposing that an imam in a mosque is teaching about the Islamic view of marriage, for example, and it's been mentioned already. And somebody who's a member of your mosque then goes out and they open up a wedding venue, or they offer services to couples getting married, but for religions of their faith and constant belief, they very graciously even tell a same-sex couple that they're not willing or able in good conscience to actually offer their services to them. They should not be forced, therefore, to do something that goes against their conscience and belief. Not that they're discriminating against the person, they're simply just saying that in terms of our belief, we're unable to do that. Please do not put us in the position where we must choose between should we obey God with eternal consequences if we do not, or should we obey the state with obviously severe sanctions, as we've seen, if you do not. Nobody should be in that position. But in that instance, not only according to this extended liability would that particular person who's maybe got the wedding venue be liable, but so would the imam, because the imam would be the one who caused them, if you like, or encouraged them in their viewpoint. And therefore, the liability can extend upwards. It can expand that net of liability. And it also includes employer-employee liability. So if you, as an employer, do not take active steps to prevent an employee from unfairly discriminating against in terms of this act, then you're also liable. So the mosque, perhaps, who might employ the imam, would also be liable. Even if they didn't know what the imam was going to say, even if the imam didn't intend to cause any offense, even if the person didn't know that they were causing offense, it doesn't matter. Once you're caught in the net, the liability is so wide and the sanctions can be very punitive. As I mentioned, one case we're dealing with, the wedding venue case, 2 million rands worth of damages is what they're looking for in that instance. And as Honorable Breytenbach also said, the problem is that the state, whether it's the South African Human Rights Commission or the Commission for Gender Equality, this bill also will give access to legal aid to people who want to bring legislation under this new bill. It literally opens up the opportunity for activists to literally club people of even conservative values. And once you're caught in that net, you're now responsible to fight your own legal case with your own money. It can be prohibitively expensive. We estimate that to get to the Constitutional Court, which may be where you'd want to take this to try and defend yourself, that can cost you, 5, 6, 7, 8 million rand. How many people have got that to defend themselves with when the state is actually paying for you to be litigated against? It is extraordinarily draconian, this bill.
Well, it certainly sounds extremely draconian. And Ahmed, Mansour, Imam, Sheikh. Now, looking at us in South Africa, we're a multicultural society, we're multi-religious, we're a multi-diverse society. And we've got so much diversity in this country. And from what Michael has just mentioned, when one looks at it and we drill down, on our day-to-day interactions with people, clearly and upfront, I think somebody mentioned that this is open to abuse. And are we likely to actually see this in the event of this bill being pushed through?
Well, yes, definitely. First of all, I think the religious groupings in South Africa, based on what the Constitution demands, enjoy a very cordial relationship in South Africa. In fact, I think a lot better than many other countries. And this is going to lead to more and more litigation. And what is worse, because government is going to fund it, the very government that does not have enough resources wants to now and fund these things. So you can imagine what is actually going to happen. But very importantly, if we note what Faisal said, that, over and above that, the punitive sanctions and institutions and employers, and I think Michael has also alluded to the fact that will be held accountable if employees make statements that may purportedly be discrimination in one way or the other. So you can imagine what a serious challenge we're going to face. But more importantly, what Faisal said is about the state having more power to regulate non-governmental institutions, and particularly religious and cultural bodies or traditional organizations. Now, given the state of governance in South Africa, can you imagine that we're leaving this in the hands of the state to be able to deal with this issue? So really, there is no doubt about it that already, because of legal resources being made available, people run to the South African Human Rights Commission again and again. So can you imagine with this additional provision in terms of this amendment, if approved, what is going to happen? They're going to be inundated. The justice system is going to be inundated. The South African police services is going to be inundated. Do they have the capacity to deal with it right now? They don't have the capacity to deal with it.
Yes, certainly. And also, I just like Glynnis' comment on this whole question surrounding capacity of dealing. And we've seen Glynnis in the past. We've seen many other aspects where we deal with, like, for instance, Michael spoke about employees. We see what has happened with things like the Department of Labor, the CCMA situation, where we see that, they have been inundated. They haven't been able to cope, to the point where we found that many of these departments are at the point of collapse, actually, and throwing more money all the time. And the same would go for the justice system. We've heard about the severe shortage as far as qualified forensic people in the country go. Now, all of this comes at a time when the country is in dire straits, when the country is in a very, very critical situation, and also at the same time throwing more money throwing more money at something which is highly controversial as this amendment bill?
Yes, it's quite true. All those institutions are under resourced and under serious constraints. So the criminal justice system certainly staggers from day to day. It is barely able to function. It is severely under-resourced, both in human resources and financially. The South African Police Service is severely under-resourced. I think we as South Africans experience that every single day. This allows insists that legal aid will be provided for those who want to litigate. Legal aid South Africa is severely under-resourced. The advocates who litigate on behalf of Legal Aid South Africa have upwards of 100 cases each. Now, any lawyer will tell you that it's impossible. It is simply impossible to give proper attention, adequate, even adequate, barely adequate attention to each and every one of those cases, because they're not spread out over a space of time. They're all happening now. It's impossible for one human being to fully concentrate on 100 matters at the same time. It's not able to be done. So when this hits, it's going to increase that workload enormously. There's going to be a lot of publicity that surrounds these matters. They're going to be high-profile matters. There's going to be a lot of extra strain and on those poor litigators. And as has already been pointed out by Michael, it's you, the person who's being litigated against, have to use your own cash. Litigation in South Africa is prohibitively expensive. It takes a huge amount of time because our courts are so overcrowded and under-resourced and overstrained. So this is an absolute recipe for disaster. It makes no logical sense whatsoever to take something that is not broken. The system works. There is sufficient legislation in place. There's sufficient protections in place. The system is working. To take that system that works and throw this at it, it makes no logical sense. And I think a part of the answer lies in Clause 9, which gives the government such far-reaching powers to interfere and introduce codes for NGOs, community-based organizations, and traditional organizations, which will allow it to prescribe how they promote equality in their relationships with other bodies and in their public activities. And we hold the view that these powers are a backdoor mechanism for the government to interfere and regulate private organizations and their affairs. And this will effectively end institutional autonomy and will result in unacceptable state intervention in the internal workings and doctrines of mostly faith-based organizations. It gives them the power to choose different codes for different organizations and institutions depending on their size, resources, and influence. And it's unacceptable within a bill aimed at reducing discrimination that the government is permitting itself the power to discriminate like this. So, again, I cannot stress enough, South Africans must fight this amendment bill. It is bad, bad, bad law. There's no space for it. It cannot work. It's not good for South Africans. The only people it's good for is the government. The rest of us are going to suffer under this piece of legislation. It's going to be unworkable. In any event, I think it's unconstitutional. I think it offends Section 16 of the Constitution. So, that's another fight. But as has been pointed out, the government litigates with your and my money, and then you and us have to find some more of your and my money to defend ourselves. So this is bad, bad law, and it should not be supported on any platform.
Yes, Faisal, I've got actually a WhatsApp message that has come through, and this is specifically, aimed at you, and in fact, it actually makes mention of Semnet as well. I just want to read out this message, and I'd like your comment. It says, what this listener is saying is, I really can't figure out the fuss or what the fuss is all about with this PEPUDA amendment. It's like someone is leading the Muslim community by the nose and getting everyone's backs up for nothing. Maybe I am missing something, but I don't see any threat for Muslims. And it goes on to say, I've seen a clip circulating on YouTube, TikTok, and Facebook by a Christian lady, I think from the ACDP, who seems to be instigating a response because of the perceived threat of the proposed amendment to religious institutions. I don't buy the hysteria behind it, and also see SEMNET and other organizations mobilizing.
Yes. First of all, thank you to the listener for the comments. Firstly, let me just address something, and I'll come back to that question. Listening to Michael, it's made me realize that we actually have been too narrow in our focus of advocacy. We've looked at the religious institutions, but the fact is the business community has to be extremely worried here as well. If I just use my own practice, I have many gay and lesbian patients. But if these amendments were passed, I'm just thinking, if a gay and somebody from the LGBT community was sitting in my reception, waiting to see me, and if one of my staff, which doesn't happen, but of course it can happen, made a comment that was perceived to be prejudicial, impugning on that person's dignity, from what Michael has just said, and I hope the listener who sent in your comment is listening, that not just the staff member, but I could be held responsible. And the point being this, our legal advisors made the same comment that Glynnis has made, that this probably won't pass constitutional muster. But on the way to that point are millions of rands of expense, and not just that, but the freedom of religion, the changing the whole landscape of how religion is preached. For example, already, you will know that those community halls that have been built by religious organizations, whether it's in the Muslim school, whether it's community halls, whether you're Muslim or not, if you want to hire that hall, at the moment, you cannot conduct any activity in that hall that is perceived to be un-Islamic. So you won't have pork, you won't have alcohol, you're not going to have, Guns N' Roses playing in that hall, because that is so whether you're Muslim or not, you cannot hire. Those are the conditions of hiring the hall, and that could become problematic. So that is the first thing, and I think I'm just thinking we need to reach out to the business community, because there's another angle here that perhaps we haven't focused on, and that is the impact on business. We've just looked at the religious angle. So that's the first thing, and just to use a simplistic example, if these amendments are passed, someone gets funding from the likes of a George Soros, who's just going to fund hundreds of millions of rands. Someone gets funding from a radical of any religious group from overseas who has money to donate, from whichever faith. They can tie the other religious communities up in litigation and stranglehold, for decades. Just this, it's not an uncommon technique used overseas. It's called lawfare. It is used very well overseas by the Israeli lobby to stifle debate. Use another example. I know this probably won't go down very well with Glynnis, but overseas legislation has been passed to equate criticism of Israel or anti-Zionism with anti-Semitism. Now, clearly, Arabs are Semites. We are of the same Abrahamic faith. We have no problem with Judaism. We got serious problems with Zionism. We got serious problems with what Israel does. But you could, under these amendments, if you look at them carefully, get someone tied up to say that if you criticize Israel, and obviously it's topical of what has happened recently, or you criticize aspect of Zionism, and say, no, that's anti-Semitism. So what, you're going to stifle the debate on that as well, using these amendments? And it's been done overseas. I can't see why it shouldn't be. It won't be done here. So the extensions of this are unbelievable. So that's just my general comment to the listener who sent in the comments. I'm not a legal expert, which is why I've left the legalese to Glynnis and to Michael. But we've read submissions from Muslim Senior Council, more than one. We've had the Association of Muslim Accountants and Lawyers look at these amendments from a legal point of view, and Michael and the advocates that I've seen on their website, and I'm sure Glynnis is an advocate herself, have looked at this, and you will see a coalition here of forces that are generally opposed. I mean, you know, we have serious issues with the DA. We certainly the ACDP that are tweeting support for what you know, the discussions we had with them on certain foreign policy issues. But the fact that such diverse groups can find common ground and see the dangers in this should tell the listener that perhaps he needs to relook or get his attorney or look at the Freedom of Religion website, where they've detailed the broadness of these definitions, the scope that Michael has so clearly discussed. And once you've done that, I can't see why anyone would say there's hysteria here. In fact, it's the opposite. In fact, something comes to mind now, and perhaps Glynnis and Imam must ask, for someone who listens a lot to our national broadcaster on SAFM, etc., I've not heard debate on that radio station on such an important topic, and now it makes me think, why not? You know, this should be something that ordinarily would have made a full hour's discussion on that on the national on that particular radio show, and it now makes me think, why this rush to pass it? Why this the attempt to perhaps keep it off the public radar? And I therefore think, you know, churches must mobilize. I think we all have to work together now, you know, go beyond what the problems are. Clearly they've been discussed, but we must now look at mass mobilization to get this message clear to the ANC. If the Justice Department, you know, is not compromised, but certainly not paying attention.
Yes, thank you for that, Faisal. Michael, looking at where we are as a country at this point in time, and we know to a large extent, you know, we've had tremendous problems over a period of time, but at the same time, we're talking about building social cohesion. We're talking about building a rainbow nation. We're talking about coming together. And when one looks at this bill and the obligations that are placed on organizations, on community-based organizations, and we can even extend it. I mean, we've spoken about business, but we can also extend it to our education system, to our educational institutions, to our schools, because we've seen so many cases over a period of time where we've heard about inequality, where we've heard about discrimination, and looking at how this is likely to impact on the social fabric of society. Because what this amendment gives is basically an open license for someone to go and report a matter, knowing he's going to be funded, knowing his legal expenses are going to be paid, and he's going to be open to just so much chaos, for want of a better term.
Yes, well, the Constitution says that we should live in a society where we celebrate our diversity, not where we are antagonistic to one another on the basis of our own interest, whatever that interest or preference or whatever it else, faith, religion may be. We are supposed to be building a society which is a cohesive society where we all come together. And we believe that this act will actually cause the opposite effect. It will cause deep divisions in our society. And that's a big problem. I think the other thing to mention as well is that we haven't mentioned the expansion of equality yet. And that is something which I think, Dr. Faisal, you alluded to when you were speaking about perhaps a resource or a hall or something that maybe an Islamic institution has built or owned or manages or what have you. And this is where the expansion of equality also comes into play, because the definition of equality is extended to equal rights and access to resources, opportunities, benefits, and advantages. In other words, you cannot preclude anybody. It's almost not so much a right of equality, but it's almost a right to entitlement. It is almost impossible. And of course, that will mean that you have been in breach of the act if you do not grant equal access. And there is no criteria that you can actually measure that against. I think another very important thing to mention is the difference between an act of parliament and a litigation in a court of law. When an act of parliament is passed into law, so let's supposing that this bill is then passed into law and it amends the Equality Act, that law is immediately enforceable and is valid up until the moment when it is overturned, either by another amendment or alternatively by litigation up to the Constitutional Court. And the Constitutional Court can obviously, ultimately, that's our apex court, it can rule that a piece of legislation is unconstitutional. But of course, in the meantime, it is in force and enforceable. So in other words, people can use it. Now, let me give you an example in terms of the existing PEPUDA. In other words, the Equality Act as it now stands. You may be aware of a case known as the Kulani case, where John Kulani, who was a journalist at the time, wrote a pretty egregious piece of journalism saying very unpleasant and derogatory things about the LGBT community, which, again, that was his opinion. But the issue was it breached, they said, hate speech, which was broadened by PEPUDA from the original constitutional definition. The original constitution, or the existing definition of hate speech in terms of the constitution is, among other things, there has to be an advocacy to hatred with an incitement to do harm. So those two have to be linked. So classic hate speech, kill the farmer, kill the Boer. Who do we want you to hate? Farmers. What do we want you to do to them? Kill them. Classic hate speech. But the PEPUDA, or the Equality Act, expanded that to include what could be reasonably understood to be something which was harmful. Now, that becomes terribly subjective because it's obviously much broader than the constitutional's definition. And the problem is that the broader you make the definition of hate speech, the less free speech you can have, because you're never quite sure what you might say might cause harm to somebody. You don't know. And what the Kulani defense did is they challenged the definition in the PEPUDA Act. They said it was unconstitutional. That matter went to the Supreme Court of Appeal last year, and they agreed, and they said that that definition, in other words, the Equality Act's definition of hate speech, is actually unconstitutional. And that case has now been heard by the Constitutional Court, who have yet to rule on it. But let's supposing that the Constitutional Court agrees with the Supreme Court of Appeal, and they say, yes, this definition of hate speech is broader than the Constitution, therefore it is unlawful, and therefore Parliament must do what the Supreme Court of Appeal says, which we're now confirming, which is you must amend that definition. The fact of the matter is that that definition, which is now declared to be illegal, unlawful, has been in force and enforceable for 21 years. And how much does it cost, as we've said, to get that case to the place where the Constitutional Court has heard it in the first place? So once something becomes law, and this PEPUDA Amendment Bill will change the law, not just of PEPUDA, but it will then reshape every other piece of legislation in South Africa. It will transform the legal landscape of South Africa. Then you have a long, long fight to try and reverse it. And that's why it is so important that we make our voices heard now, while it is in the stage we're asking for comments, and we push back against this, because we do not want to live with the consequences.
Ahmed, Mansour, Sheikh Imam, Michael's just been talking about equality, and one aspect I'd like to touch on is when we're talking about equality and equal access to resources, because that was a point that was made earlier on in the discussion as well. And as far as access to the country's resources are concerned, and we've seen, whether we're talking about white monopoly capital, whether we're talking about black monopoly capital, we're talking about the tenderpreneurs, we're talking about what's been playing out in the State Capture Commission. And when one looks at who has had access to resources and how equal those distribution of resources, or how unequal those resources have been, and just your thoughts, because obviously this is an issue when we're talking about equality. This is a major issue that one needs to take into account.
Yeah, let me just start off by saying, it's a government's responsibility to address this high levels of inequality, and if you want equal distribution of the wealth of this country and resources. And I don't believe this amendment that we're talking about is going to bring about any change and deal with the issues that people have in the country in terms of the high levels of inequality. There is no doubt about it that 27 years later, the country is still in the hands of a few. But over and above that, if you're talking about the issue of resources and high inequality in South Africa, it is solely as a result of the way we govern this country. And what you have found is, and I'm going to give you an example, in the last couple of years, this country has created 17,500 black millionaires, all at the expense of the poorest of the poor. So There is resources. It's just that it's benefiting a few people that are enriching themselves at the expense of the masses. Only government is able to put in measures to deal with that problem. Now, the question is, if you talk about the amount of money that is lost, and Honorable Breytenbach will agree with me, there's hundreds of billions of rands being lost in this country as a result of tenders and corruption. 300 billion rand alone through procurement. But the reason why you can't deal with that problem so that you can take those resources and distribute to the poorest of the poor is simply because political parties depend on these tenders to survive. If you see exactly what is happening right now with the governing party, they don't have no monies to pay salaries and rentals and a whole lot of things. It's because they've been depending on it. So it's not this amendment that's going to be able to deal with them. But I also want to talk about, I think one of the callers said a few things there. I think the caller is concentrating only on the issue of religion. And this bill does not only deal with the aspect of religion. And like I think Michael had earlier on said on the challenges that employers will face, if an employee does something, the employee is being held to account for it. So I think that's the other issue I think we need. But I want you to look at the irony of this. You commit a murder in South Africa, and government provides you legal aid to go and defend yourself after you violated the human rights of somebody else. Here is somebody who's making an allegation. Government wants to fund this person who's making the allegation, but the person that his allegations are made against is now going to have to go and spend his money to prove his innocence. Now, I cannot actually understand this. And yet we know that, and I think Honorable Breytenbach has alluded to the fact that the impact on the judiciary and the criminal justice system in South Africa, it is in a state of crisis. There is no doubt about it. So if you want to deal with the levels of equal distribution of the resources in the country, that is the responsibility of government. Policies are there. The problem is that the people who are responsible to do that are actually enriching themselves at the expense of the poorest of the poor. Now, you can't go and find a change in this bill. This bill is not talking about that. This bill is talking about giving the state so much of power that they will undermine all these non-governmental organizations and institutions. That is basically what they are going to do. So we don't believe that there is a need for this. Let us go out there and find a solution to the challenges that people are facing in this country because of the way we distribute the resources in this country. But you're never going to be able to address it with this amendment. So, I think what the other caller needs to also understand, where did this come from suddenly? Because the current act makes provision for unlawful discrimination, and there's adequate protection there. Suddenly you get this piece of amendment that's being pushed. And that is what's making so many people suspicious. Where did it come from? What is the rationale behind it? What is the hidden agenda behind it? Why do people want this when there is added protection? And in order to do that, you're even willing to go and pay for legal aid for these people who are going to make the allegation. So really, something does not seem to appear. But I think what is important, you're not going to easily get a restrict Parliament to approve this bill. Unless, like I think Faisal and Michael said, I think that we need the large numbers of people from communities to come up and take a stand against him. It's exactly the same thing under the Section 25. We know what is going to happen with that, but it's being pushed and pushed and pushed, and it's not going to be the interest of the country. So I think what we need is an uprising from people to stand up and make government accountable so that they don't go based on majority and pass bills that is going to impact on their lives in the years to come.
Yes. Glynnis, now the DA has made it very, very clear that you are going to oppose this bill at every opportunity. At the same time, you are encouraging South Africans to oppose this bill, and also looking at some of your reasoning behind this, and one of them being the system is open to all types of abuse. And I'm just quoting from this article, which says, not least from government whose recent history has proven that any loophole will be exploited to advantage the politically connected, the corrupt, and the cadres.
Yes, well, certainly. You don't need to tell South Africans that. We all know that as Sheikh Imam has already said, corruption is rife, and money that could and should have been used to uplift ordinary South Africans, to increase the general equality amongst South Africans and give all South Africans a better life, has been stolen in the billions, in the hundreds of billions, in this type of situation. So you don't need to explain to South Africans that there's that danger, really, because they live it every day. And bearing in mind that there is already legislation in place that, in our view, provides more than adequate protection, then the rationale behind this piece of legislation cannot be the increasing of equality and increasing those protections, because it's already adequately protected, so there must be another reason. And that's what's bothering us. We don't know why it's being rushed, we don't know why it's being pushed. And the other reasons are, if you look into the bill, they become a little more clear. For instance, the removal of intent reintroduces strict liability in South African law, which we've tried to move away from in a constitutional democracy. And it will have a chilling effect on, for instance, free speech. So that will suit the governing party, that free speech is impacted upon. So you won't be able to criticize so freely. Newspapers will be much more careful about what they write. Everybody will, go around whispering their objections instead of standing up and saying them whenever they want to, because the consequences attached to that will be, as has already been pointed out, enormous. So the motivation behind this piece of legislation cannot be to better enforce equality, because it doesn't do that. It simply doesn't do that. So we must look for different reasons, and we'll find those reasons in it. Narrowing your rights to freedom of speech, so that will automatically impact on the freedom of the press. Narrowing your rights to be able to criticize other people, and that includes the government. If you do criticize anybody, if you do express your views, if you exercise your right to free speech, and you offend somebody, there will be seriously draconian consequences attached to that. So it will have a chilling effect on the entire society. Everyone will become afraid to say what they think. Everyone will become suspicious of their neighbors, and you start moving in a direction of a dictatorship, of a one-party state, because everyone's too afraid to speak and say, and the press will not be free, because if they print something that's offensive to anybody at all, for whatever subjective reason, not even objective, subjective reason, then there's trouble. So, and as we've already said, litigation is prohibitive. So this is a really, really, really bad piece of legislation. It doesn't belong in a constitutional democracy, and South Africans must fight it. Not for my best interests, but for their own best interests.
Well, thank you for that, Glynnis. Just to the panelists, we're going to go for a quick ad break. We'll be back.
Something fresh. Listen to Salam Media.
The combined dam levels for the Port Elizabeth area is at a shocking 11%. 1 July is day zero for the Kruger Dam, resulting in dry taps for hundreds of families in the surrounding areas of Port Elizabeth. Help us strategize. Support our water drive in the Eastern Cape region of South Africa. Donate your lilla towards the erecting of JoJo tanks in impoverished areas and for the vehicles to deliver water in areas of need. Donate to the Al-Fida Foundation. Visit our website at www.alfida.co.za or contact us at 041 484 1288.
Shimmer, sparkle, captivate. Nothing less than a masterpiece. Droplets of gold inspires precious design. Platinum bursts with intricate freshness. And every pure diamond becomes more than just a girl's best friend. Voda Gold Gem Jewelers, where timeless dreams become a reality. Come to us. We tailor-make designer gold, platinum and diamond jewelry. Trade in or remodel your old gold. Clad yourself with classy name-branded watches. We offer insurance valuation and freezer card calculation. Visit us at 534 Ridge Road, Overport, or call 031 208 9142. Voda Gold Gem Jewelers, manufacturers of fine gold and diamond jewelry.
We believe in Allah. We believe that all life is sacred, that everyone has the right to dignity. We believe in going the extra mile to help people in areas others don't go. And we believe in the words of Allah, that with difficulty comes ease, Islamic relief. We are one.
As the crisis in Palestine continues, the Africa Muslims Agency teams are on the ground facilitating emergency food and medical assistance to the affected families. Donate 15,000 rand or any amount and help the people of Palestine. Call AMA now on 083-251-9376 or donate online at africamuslimsagency.co.za. Africa Muslims Agency, inspiring the spirit of giving.
Salam Media, a global voice for humanity.
Time is just gone, 8:21 p.m. and this is Wednesday nights with United Wadi, and tonight we are looking at PEPUDA. We're looking at the amendment bill, and the question that we are asking is how concerned should South Africans be? We have assembled a panel to take this discussion, and an in-depth discussion, I must add. We've got Michael Swain, and we also have got Ahmed, Mansour, Imam Sheikh. We've got Dr. Faisal Suiliman and Glynnis Breytenbach as part of the panel. Now, Faisal, just to come through to you as we continue the discussion, and I've looked at the statement that has been issued by our Jamiatul Ulama South Africa, and one of the points that they make is the question surrounding expression of our beliefs and religious values, and talking about the state regulating religion. And this is a major concern, because what they're also saying, it is quite foreseeable that people and institutions of faith will be dragged before court simply because someone does not like or does not agree or offended by the expression. Now, we've seen what has happened across the world. We see what has happened in Europe. We see what has taken place in the United States of America as well, where we find that a lot of these laws that are made by these governments, by these countries, and how they impact on local communities. We've seen what has happened with, homegrown imams. We've seen how mosques are regulated, what he said, what the imam says, what he doesn't say. Are we likely to end up like we see what is happening in Europe? And, as a result of that, obviously it rubs off. And as the question I raised to Michael was in terms of the social fabric of society. Does it make people Islamophobic, or possibly it could be any other religion, whether it's anti-Semitism or whatever it is? These are possible likely consequences as a result of a piece of legislation like this.
Look, to the point of the Jamiat's letter, I think Michael has clearly given examples and explained how this will impact religion and the processes involved. And I think the most salient point that Michael has made, among many, is the fact that Imam and Glynnis has spoken to the fact about the courts, and for me that's too far gone. I don't even want one toe, let alone a foot, of the government or this legislation impacting on our lives and on religion, let alone the 2 feet, and then we need to worry about the justice system and of course the constitutional court, the legalese, the backups, all of that. It's too far gone if it reaches that stage. This is so drastic. This is such a dangerous. These amendments, these proposed amendments, are so dangerous. They need to be nipped into the bud clearly now. And look, it may be obvious that one of the reasons for the rushing is that we are at the moment focused on COVID. We're looking for the president's iPad. We are busy on the Zondo Commission. The state, every day there's so much to attract our attention and make the news. That something like this, so drastic, is really not getting the publicity it not just deserves, it necessitates. in the public sphere, in domains. And therefore, perhaps the rush to get it passed, while you know, our eyes are on everything else, and we, you know, COVID takes such a big part of our lives. So perhaps that is the reason for the rush, or obviously another interest lobby or whoever's pushing for this fears that, you know, it may be too late if people really find out the repercussions. As far as Islamophobia goes, I think what you can, the Ispingo case clearly demonstrates what will happen to any religious community. You know, someone playing hymns, singing hymns in a complex, playing you know, bhajans, Hindu chanting, reading the Quran loud, reading verses of the Old Testament, you know, loud, something that supposedly you know, talks about violence or about punishment. You know, your door's open and someone walks past and you're talking. I mean, the implications of this, and the point is the burden of proof and the resources that are allocated to the complainant are stupendous. As Imam has pointed out, you know, it doesn't balance. So in Europe, you've seen Islamophobia clearly post 9/11, the war on terror, etc. You know, dominate much of the discourse, and therefore the attacks on Islam. You know, the portrayal of Muslims in the media, in your movies, etc. So that has already, you know, largely contributed to the kind of narrow stereotype of Muslims. This legislation just opens the door for anybody who has a problem with any other religious group or faith or even a belief to simply abuse the system. You know, as a doctor, I see tons of gender-based violence, and clearly we have a huge problem. But we also see that there's abuse of some of the laws. You know, many, not a lot, but many women use the system and the burden of some of the laws, or the implication that men are inherently guilty or are guilty and need to prove themselves innocent, to abuse the system. And men have often been locked up on a Friday night because, you know, you're only going to get bail or see on Monday morning by women who are abusing its system. And that is in a system where already there's so much abuse of women in our country. So can you imagine something as sensitive, as emotive, as religion, as faith, as a firmly held belief? We have to see it only now in the debates that rage around COVID. You know, anti-vaxxers, etc. That some things are so emotive and people can be so dogmatic about, that when you have a bill like this that widens the scope, that completely changes the burden of proof and the assumption of guilt and the resources towards you know, the complainant, it staggers. I think Glynnis has said it, or Michael has said it. It boggles the mind that how these proposals have even come to be, and therefore the question about who is behind it, and the need for us. And I say it again, it's no more just religion. I think we need to get the business community, probably the most resources and well organized, to seriously look at these proposals and how it's going to impact on business. So yes, clearly Europe has a problem. We don't want to import the sort of Islamophobia and narrow-minded view of Muslims that you have there. You know, there's a right-wing shift, a nationalistic shift all over the world. We've seen, you know, right-wing parties has come to the fore even in South America. And this bill, as I mentioned earlier, you just have to get the wrong funder or a large interest group, you know, who have deep pockets, and you can literally tie people up in court for decades, literally for decades. And clearly what you will do, and Michael has said it, is upset social fabric. You'll turn people against each other. You know, we have had enough examples in Germany, in Rwanda, we see it now. We've seen, you know, self-hate all over the world. We've seen it in our own country all the time. We clearly have many episodes of mass xenophobia, people, you know, burnt alive. We've got examples. We don't need to have a piece of legislation that just makes it easier to be hateful or to be litigious on you know, on grounds that are spurious at best.
Yes, Michael, I've had the opportunity on a previous show where I've engaged briefly with the likes of the ACDP. And just looking at your interaction, and, I've just basically given you an insight in terms of what the local Muslim organization, religious body has to say regarding this, and they are opposing it. How have you had any interaction with any of the other religious denominations? What are their thoughts? How do they feel about this amendment?
Well, unanimously, the views that we have heard, and I've spoken to the leadership of several denominations. I'm also speaking to some of the traditional African, the spirituality, religious groupings as well. We did have the privilege of speaking to the United Ulama Council of South Africa the other day. So we are broad and wide, really just helping people to, first of all, understand it. And the unanimous response is that this is absolutely unacceptable. I'd like to maybe just circle back to this issue which Dr. Faisal was touching on as well. One of the things that I think you can take a cue from, and one of your callers said they think this is a big fuss about nothing, is there is a professor of constitutional law at UCT who himself is not at all in favor of religion. And he welcomes this bill. And to quote from his article that he wrote on it, and he should know because he is a professor of constitutional law, so he will understand better than anybody the potential impact that this could have. He welcomes it because it will not allow individuals or organizations, and I quote, to escape censure for their outrageous and harmful views merely because they are couched in religious terms. And it will obviously then give activists funding from the state potentially to attack what he calls the corrosive impact of religious teachings and the harm caused by them. That doesn't sound like something that is just thrown out randomly. That is from somebody who well understands the implications of this law and potentially might also be somebody who might literally pick up the cudgel with funding by the state in order to beat the religious community that he obviously dislikes so intensely. So that is one problem, again, from activists, which I think we're going to see if this thing goes through. But another thing that I really want to focus on is the encroachment and the intrusion of the state through this bill into the internal workings of religious organizations, in fact, all organizations. So faith-based schools or institutes of learnings will be equally affected. And what this bill also says is it puts, and again, this is extremely unusual in legal terms, it puts a positive duty on you. In other words, you have no option but to comply. And this is what it says you must do. You must, all persons, including natural and juristic persons, which obviously is businesses, NGOs, community-based organizations, traditional institutions, which would obviously therefore include all the religious institutions, must promote equality in their relationships with other bodies and in their public activities. And the equality that they're talking about is obviously the equality that is going to be legislated by this bill and reinforced by individualized, potentially, codes of practice and regulations which come from the responsible minister, which in the case of the religious community will probably be the Copta minister, currently Minister Nkosazana Dlamini Zuma. That means that they will literally be able to superimpose their view of equality upon your faith, upon your tenets of belief, and you must comply. You must make the adjustments. So if you have, for example, let's say dress codes or access for certain genders into certain parts of a religious building or something along those lines, that will be simply swept away. And if you try to stand up against it, you're going to run foul of the bill in and of itself because you must apply. It forces you to apply those standards of equality and in their views of unfair discrimination. And obviously, it opens it up to litigation from anybody who feels that you're not doing exactly what you're supposed to do. So this is an extremely invasive, broad-reaching piece of legislation. It pretty much ends religious freedom, for that matter. Your constitution, if it is in any way falls foul of this bill, the legislation that will come through as a result of it, that cannot stand in the way of it, and you will simply just adapt, or alternatively, you can face serious sanctions. So we are honestly not able to fix this as we see it. And that is why FORSA has said from the beginning, we need to scrap this in its entirety. It's not necessary. It's not in any way helpful to create the type of society that I think any of us would really want to live in. And that is why we're saying we need to push back. We need to send our submissions in. And I just want to pick up on one thing, and maybe Honorable Breytenbach will comment on this as well. You know, we're talking about process here, and there is a very clear democratic process that we need to be following, because when government calls for comment, we, in terms of our constitutional rights as citizens of this country, as those who live in this country, we have now the right to comment. In this instance, they literally have blocked comment in terms of their email overflowing or their email box being full. And they wrote to us and we wrote to them to challenge this, and they apologized. They're sorry for the inconvenience. Well, it's not inconvenient when you're not able to exercise your democratic right to push back and to make your voice heard when you've been invited to do so by government. It is not inconvenient when perhaps your comments are simply disregarded or ignored, or you're unable to make them at all, because there is a fatal flaw, we believe, in this process, even of receiving comments on this bill. So we do believe, nevertheless, that we need to keep on sending in our submissions, because ultimately that can be effective. I would like to maybe give an example of where this has happened. You may recall a few years ago now, the Prevention of Hate Crimes and Hate Speech bill was on the table, and that would have criminalized certain hate speech, which literally would have included just about anything that you would have said from a pulpit, whether it would be in a mosque or a church or anywhere else. And that carried a 3-year jail sentence. There was a massive pushback against that. Some, I think, 50, 60,000 submissions were made. And as a consequence, government did then, at least in the next drafting, put a specific clause in to protect bona fide teaching and preaching of religion, as long as, of course, it didn't amount to an advocacy to hatred or an incitement to violence. Fair enough. But we believe that that is why it is so important that while we still have the opportunity, and before the 30th of June, which is the cutoff date, submissions are made. And it is easy to make a submission, by the way. One of the ways you can do is to simply go to our website, forsa.org.za, and click on the link there. That takes you to a neutral platform where you can make your submission with just a few clicks. Not difficult, but very important.
Well, thank you for that, Michael. I've got another question that's come through from a listener, and I think this one's for Imam Mansour, and just to bring him into the discussion regarding, and the question that's being asked is, I don't mind some Muslim politicians using it to mobilize for the upcoming elections, but don't mislead our community into thinking we are under threat by our own democratic government. That is just absurd. Just your reaction to this comment.
Well, the caller is entitled to his opinion, but let me give you a good example. Any religious grouping that teaches its own religion, and then you have one student or child that decides, I want to go there. There's no provision in this particular, and I'll give you an example. If it's a Muslim school, which accommodates 500 Muslim students, so they have educators and things to teach in that particular language and the syllabus based on that. And then you have a non-Muslim student of any other religion and vice versa that will want to attend that school. It is now incumbent on that school to provide an educator to accommodate that learner. That is basically what this bill is all about. So the issue of the freedom of religion is completely taken away from you. You cannot discriminate with that person. Now, it will happen exactly the same thing with all religious groupings in South Africa. And that is why you find that the Hindu community is opposing it, the Christian community, the ACDP, and everybody is opposing it. There must be a reason why all these people are opposing it. This has nothing to do with politics. This is about ensuring. And the most important thing is this. One is to ensure religious freedom in the country. And secondly, and very, very importantly, that the current legislation is adequate. It makes provision for any forms of discrimination. Now, here the government wants to go, and I'll tell you what is important for me. There's never been any discussion on any limitations that may exist in the current legislation that we could look at. Rather than just implementing and wanting to amend these things, there hasn't been any extensive deliberations on whether there is limitations currently in legislation and that we're having challenges as a result of that. So what does it tell you in the absence of all that? For some reason or the other, they want to push this to be able to get it approved in a short space of time without much discussion, even though there's objections. And the other very important thing is, and I think Honorable Breytenbach will come in there because she's on the Justice Committee, you know, as to how many people have objected and how many people were for it, to be able to try and balance it with 59 million people in South Africa. What percentage of objections have come in that you still decide to undermine the entire process and the views of this very large percentage of people that are objecting and still want to go and pass the bill? Then what is the purpose of this public participation process? So really, you know, my view is this, that this is going to infringe on the religious freedom, and very importantly, not just from a religious perspective, but on your freedom of speech to be able to express yourself in any matter. I give you an example from an employee perspective. If two employees, one is discriminated against the other, in terms of this bill, if the employer does not do anything about it, the employer will be equally responsible and liable for it. Whether he done it in a satisfactory manner or not is not important. If it does not suit the complainant in this matter, the employer is also going to have to be held accountable. So really, I don't believe that it is necessary to go that route. And like I've said before, the current legislation adequately provides for discrimination at any levels, whether it's race, whether it's gender, whether it's religion, and things in South Africa.
Yes, Glynnis, I just like your thoughts. Okay, Faisal, continue.
Yeah, I just want to, you know, I'm here to defend Mansour, but going to that comment, the caller makes the point that says, if I heard it correctly, that, you know, do not believe something that our democratically elected government is, in fact, basically saying that the fact that it's a democratically elected government, clearly we know our past, means that one, it's almost infallible, or that it is not capable of making mistakes, or you just have to look around. For someone who campaigned for the ANC for the better part of almost 3 decades, you know, I'm saying, President Mandela said, if the ANC does to you what apartheid did to you, then you must do to the ANC what you did to apartheid. President Mandela said that. So, you know, it doesn't mean that if you know, the present ruling party has been democratically elected, that they're all saints. Clearly, what's going on in the moment shows you the opposite. And if we take out the whole corruption thing, even in this case, it is the nature of politicians to put their finger into pies where it shouldn't be. And in this case, it's you know, I mean, Michael and Brayton have clearly spelled out the dangers here. And to suggest that because it's coming from the ANC, it is not fraught with danger is really erroneous. Just look around and see what happens. You know, so we cannot say, oh yes, it's a democratic. You know, President Trump was elected well, I suppose we can you know, debate that, but he was elected democratically. Tony Blair was elected democratically. You know, we've seen what they've done. You know, the National Party, the NGK, they did have elections. So, you know, you could argue. So really, that is the nonsensical argument. We have to take this bill, no matter where it came from, who pushed it. As it stands, it's going to change. Really, it doesn't. It maybe sound I'm being, you know, hyperbole here or drama queen, but really, it's going to change the very way you live your life. It potentially has. And why would you even want that potential at all? When, has been said, there is enough legislation to adequately address whatever it is. clearly it's not there to improve the lives of the impoverished, as Mansour has explained earlier. So what other agenda is behind this? And the fact that it's been rushed, so little time for comment, should tell you that there's something wrong here.
Yes, obviously, Glynnis, is what Faisal has said. Where there's smoke, there's fire, and clearly there are certain things that are playing around in the background, and we've been talking through this throughout the entire show in terms of there are still many, many unknowns. Now, just your thoughts also, and I think obviously this question was about politicians using this to mobilize for the upcoming elections, and I'm trying to understand, why would a politician use this as an opportunity to mobilize for an election, and at the same time talking about this threat by our own democratic government?
Thanks. Yes. Well, as Sheikh Imam said, there's no. Everybody's entitled to their own opinion. I would like to sharply disagree with that view that that any politician is using or abusing this in the lead up to the elections. There's that honestly, with the greatest of respect, makes very little sense. We're objecting to this because it's bad law, it's a bad bill, and it's going to impact severely on the lives of all South Africans, not from one political party, not from one political persuasion, it's one religious persuasion. It's going to impact on the lives of every single South African, regardless of your religion, regardless of your race, regardless of your political affiliation. You're going to find that your rights are getting fewer and fewer, and the control of the government is getting bigger and bigger. And that is something that in a constitutional democracy you want to avoid, and it should in fact be the opposite. People must realize, on a careful reading of this piece of draft legislation, that the choice of organizations which the state chooses to impose codes upon, it could well be open to abuse. And given our most recent history, it will be open to abuse. The state can selectively choose which entities it focuses upon, and how onerous the obligation which applied to selected institutions will be. So if they don't like the Boy Scouts, they can, to all intents and purposes, close them down. This could result in selectively and politically motivated application of codes upon organizations which the state might find undesirable, and they could find them undesirable for a variety of reasons. A free press may well be undesirable to a state that's being exposed on a daily basis. And any institution, the Independent Electoral Commission, any institution is going to be subjected to codes that the government can interfere with, dictate to, and impose limitations upon. And as Michael has already said, you don't have a choice, you must oblige. Otherwise you're in trouble. So this has got nothing to do with petty party politics, not at all. This is all about protecting the rights of every South African citizen, regardless of their persuasion in any field. Party politics is not part of this. This is bad law, and we need to fight it.
Well, I see we've got about 10 minutes or so before we end of the show, and I'm going to go around the panel, and I'll give you possibly about 2 or 3 minutes, just obviously to your closing comments. And I do believe that, we've covered quite a bit as far as the bill is concerned. We've given a fair overview and a better understanding as far as what this amendment bill is all about. So, Michael, I'm going to start off with you. You've got about 2 or 3 minutes, just final thoughts.
Yeah, I think it's probably worthwhile just circling back to the sanctions that can be applied if you actually fall foul of this, because one of those sanctions can obviously be a significant fine. A sanction can be to be told either you must do something or you must cease doing something. So let's take an imam who might be preaching one of the doctrines or the tenets of the Islamic faith, and somebody believes that somehow prejudices them, or somehow that impugns their dignity. And they go to court and they claim discrimination, and they win the case. And the court basically says that a fine might have to be paid. They could perhaps even take away the non-profit status from the mosque. They could do all sorts of things. And let's say that imam says, no, I'm not going to do that. I must obey God, I must obey Allah, rather than what the state says, or rather than what the court is saying. Well, the ultimate penalty for contempt of court, because now you're going against a court order, which is basically you're going against the state, you're going against the whole legal system, is you can not only be fined almost limitlessly, but you can also be placed in jail. So the sanctions for this, and we have said it is possible with this PEPUDA amendment bill going through the way that it is, that people of faith will literally be placed in jail simply for living out, for expressing their faith. And therefore, from a freedom of religion point of view, and as I said, for SA, we stand for freedom for all faiths. From a freedom of religion point of view, this is an absolute death knell to religious freedom. We are persuaded fully it is unconstitutional, and we believe that it is imperative that people, while we still have the opportunity, make submissions. And we would recommend that you simply go to our website for no other reason than because there's a very quick click-through link where you can make on a neutral platform a submission and voice your opposition. Let your voice be heard. Every voice counts. So that's what we would recommend that people do.
Ahmed Mansour, Imam Sheikh.
Yeah, Jazakallah, thank you for that. You know, if I wanted to political, then I should speak about the fact, I should talk about corruption in South Africa. I should talk about that only 18 out of 257 municipalities got a clean audit. I can talk about the high levels of crime. I can talk about the high levels of unemployment in South Africa. I can talk about the mess the country is in. I think if I did that, yes, I can get some votes. So clearly, I have so much that I can talk about. But coming back to, I think, what I've said earlier on, you know, as the National Freedom Party, we are not satisfied that there is a need for this. And this is solely based on what is in front of us. There is legislation which adequately provides for it. This thing has come as a surprise to us, as a matter of urgency. We don't understand why. We don't know where it is coming from. There's not enough convincing as to why this needs to be amended when there's adequate provision. Then the fact that you want to fund the complainant in this matter, and at the same time you're expecting the other side, who the allegations are made against, to go and fund his own, is going to open this thing to abuse. And we've already agreed with Honorable Breytenbach saying, you can see that the pressure on the criminal justice system in South Africa is immense. They clearly cannot deal with this. So the question that arises is, why do we need any amendments if the current legislation provides? And we are not convinced, to be honest with you. We are not. What we need to do is to have mass mobilization to come out and oppose this. Not only this, that any bill that gets passed in South Africa at the moment and comes through Parliament and is rushed, and particularly if they do not want to pay attention to the objections that are raised by people, because you said this earlier on, you know, that the people shall govern. Where are the people governing when a few people decide because we have a majority, we will take this decision? So let me tell you that it's nothing to do with politics. It is in the best interest of people. We cannot have the state impacting on the religious freedom of our people or your freedom of speech. And like we also heard earlier on, it will affect the media, it will affect everybody in this country. We believe this is bad. It should not be amended. We should not allow it. And that is the route we are going to go. What is important here is this. I am not aware of, other than whoever has brought this, of one political party in Parliament that is supporting it at this stage. I'm not sure if you're aware of that, but I'm not aware of anyone that is supporting this at this stage. So it's not any political party that is trying to politic or something. This is the decision based on what we see in front of us, that we are not satisfied. It's the interest of the South African society, particularly religious freedom in South Africa.
Well, thank you for that, Ahmed Mansour. Glynnis, final thoughts.
Thanks, Ineet. Yes, you know, in South Africa, our freedoms have been hard won. And as Dr. Faisal said, we know our history. Anything that seeks to limit our freedoms, anything that seeks to limit our ability to think for ourselves, express ourselves, give our views publicly, within reason, within the bounds of our very good constitution, we should be deeply suspicious of. And this bill seeks to do that. And we remain deeply suspicious of it, and we will oppose it. Thank you.
Thank you for that, Glynnis. Normally, Faisal, they say a lady has a final word, but I'll give you that opportunity tonight.
Thank you, Inayat. Look, I think we must focus our energies now on how to oppose this, to overcome the obfuscation Glynnis spoke about earlier. As you would have seen, we've already been asking, and of course, this Friday is the last Friday, that our imams dedicate, our appeal to the trustees, the imams, etc., to dedicate the Friday sermon to this. We've got a petition going at the moment, to raise awareness and get people to sign. I know it's gone a few thousand now, but clearly not enough. We're reaching out to the students to help us. And I think all of us now have to work. And I think, the DA, the ACDP, the NFP have to work very hard to make a big fuss of this in the legislature. And I think, as I mentioned earlier, I think we need to go directly to the ruling party. The fact that there's a municipal election coming up, I'm not sure if it provides any leverage. But the fact is, I think, I'm not sure, the large, maybe we need to, Michael may know, whether, people like the SACC, which are clearly a huge grouping, very political, very outspoken, the Anglican Church, etc., usually quite vociferous where they are, because, SAC, for example, as we know, has a very close relationship with the ANC, maybe not recently, for reasons we know well, but those are voices that the ANC may listen to, if not, what are considered minority communities. The ZCC, the Shembe churches, these are huge constituencies that I think need to be reached out to. And within our own community, we are doing this. We are using Michael's template of his website to send to people and ask them to fill in and submit. So I think we must focus our energies on making a big fuss. And I think, now that I remember, I haven't heard of this on ASM. Tomorrow will be maybe all of us need to be writing to SAFM and to the radio stations like that to ask, why isn't this being covered? Such an important piece of legislation doesn't seem to have made the important radio stations, SABC News, etc. I haven't seen it on any of the news platforms. So I think this is where we need to focus our energy now.
Well, thank you very much for that, Faisal. Jazakallah for that. And to you, Michael, Ahmed, Mansour, Sheikh Imam, Glynnis, Breytenbach, and also Faisal Suiliman. We thank you for your time with us. I know, Glynnis, at the beginning of the show, when you were talking to my engineer, you said 2 hours. But what they say, when you're having fun, time just flies. But to all of you, I appreciate your time with us this evening.
Thank you for having us.
Thank you very much. Thank you.
Good night to everybody.
Thanks.
Well, that brings us to the end of our discussion this evening and Wednesday nights with Inayat Wadi, and a much needed discussion regarding a PEPUDA. And we've basically given you an overview as to what PEPUDA is all about, the promotion of equality and prevention unfair discrimination, also known as the Equality Act. But these amendments, obviously, from what you've heard from the panel, there are some serious concerns. And more importantly, we have until the 30th of June to basically object. And as Michael mentioned, 4SA, it's on their website as well, Faisal Suiliman as well, in terms of the petition. And the more we can get out, the bigger the impact will be. And with that, I'm going to be signing off once again. It's been wonderful being in your company. From myself and the team, Assalamu alaikum wa rahmatullahi wa barakatuh.